Today's docket turns into something you don't see every day. A judge pushing back hard against weak probable cause. Multiple DWI arrests. A fleeing case. Officers writing reports that may not hold up under scrutiny. And instead of rubber stamping charges, this judge demands specifics. Not assumptions, not vague wording, but actual evidence. Odor of alcohol? That's not enough. Unsafe speed? Prove it. If you've ever wondered how probable cause really works, and how thin cases can collapse in real time, this hearing is a masterclass. Let's break it down.
Let's roll, nerds.
Good morning, Your Honor.
Hey,
How's it going?
it's been a while. How are you? What's
Doing all right.
new?
Yes. Let's guess.
I'm right. Thanks. Good morning, Mr. McGaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mireles picked up a new case.
Yeah, and he came in, checked in and left saying he had other places to go.
What?
I warned him that if he left, that more than likely a warrant will be issued for his arrest.
Next time,
I can't, because I'm on the technical. That's part of the problem.
all right.
But I agree.
Mr. McGaskey, we're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just please don't say it.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything
odor.
else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand.
It's just
I understand, Michael, but I need just a little bit more than just an odor in an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Yeah, all right, no, I'm gonna find no probable cause, Mr. McGaskey. It's very possible if they take it to a grand jury and indict it, but so.
Let's talk about what just happened, because this is huge. The judge found no probable cause on a DWI tied to a crash. Why? Because legally, an odor of alcohol plus an admission to drinking, without knowing when, how much, or additional signs like slurred speech or bloodshot eyes, may not cross the threshold. Probable cause isn't about suspicion. It's about articulable facts. The judge is basically saying, give me more. Now, here's the interesting part. She even warns the defendant that the case could still go to a grand jury. So, this isn't an acquittal, it's a procedural safeguard. What do you think? Should an accident plus alcohol odor be enough?
I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm gonna find no probable cause. Just take a seat for a moment.
Thank you, Judge.
Thank you, Mr. Jeff. All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank two beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the gyms, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1-leg stand. He also noticed that I think she took off her boots for the 1-leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, I just, an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know.
But
Procedure for
right, I get the
SFSTs,
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
But
Yeah.
it seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
And again, no probable cause. But notice the contrast. This time, the state actually had more. Speeding 94 in a 65, odor of alcohol, admission to 2 drinks, confusion during field sobriety tests, stumbling while removing boots. The judge still wasn't satisfied with just odor plus admission. She drills into timing, a 2-hour gap between last drink and stop, and even discusses alcohol dissipation rates. This is a judge applying strict legal standards consistently. She's not minimizing DWI risks. She literally lectures about daily deaths, but she's separating policy concerns from constitutional requirements. That's a tightrope walk. Would another judge have ruled differently?
Probable cause.
Yes, Judge.
Thanks, Rich.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right, please take a seat. You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
With the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
he began driving according to the officer in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius, you know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them, because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for a
Now,
moment.
this is where it gets really interesting. In the fleeing case, the judge refuses to accept vague language like unsafe speed and suspicious manner. She calls it what it is, conclusory. That word matters. In legal writing, conclusory statements are claims without supporting detail. Saying someone drove unsafely means nothing unless you explain how. 10 miles over, swerving, running a stop sign. The judge is essentially putting law enforcement reports under a microscope and saying, we need better articulation. And that's critical because probable cause must be grounded in specific observable conduct, not hunches, not vibes,
Taking a
facts.
seat for me momentarily, okay? Okay. Don't leave, Mr. Shaw. Okay, who's next? Jaramillo Jimenez? You were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 28th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it operate without all of its lighting equipment activated during the nighttime. Upon contact with the defendant, who is the driver and sole occupant, officers observed the suspect to have slurred speech, bloodshot eyes, and an odor of alcoholic beverage. Defendant admitted to drinking 2 alcoholic beverages about 1 to 2 hours prior. SFSTs were conducted, 6 out of 6 HGM, 7 out of 8 walk and turn, 2 out of 4 one-leg stand. DICs were read, but breath was refused, and a search warrant was signed and executed. The defendant does also not have an eligible driver's license, Judge.
Again, we have to go on an offense writing report, just class. I mean, it's completely conclusory. Read me the first sentence. Why the PC for the stop?
Read from the DIMS really quickly, Judge. I just want to make sure it's correct.
Without all of its nighttime equipment on. What on earth does that mean?
See if we can read it from if we have the offense report, Judge, because that's what
It's
it's DIMS.
over and over and over and over. I mean, headlights, brake lights, turn lights.
Fog lamps, my favorite kind of light.
I'm just seeing in the offense report, Judge, that driving without lights activated during nighttime.
Better. So you're saying he was driving at night without headlights? Is that?
That's what I believe this offense report is stating. It doesn't specify which lights, unfortunately.
I mean,
This final DWI shows the other side of the equation. Here, the officer notes slurred speech, bloodshot eyes, odor of alcohol, admission to drinking 1 to 2 hours prior, and near perfect indicators on HGN, 6 out of 6. That's very different from the earlier cases. But once again, the judge zeroes in on the stop itself. If the initial traffic stop isn't justified, everything that follows could collapse. Operating without all nighttime lighting equipment activated, that has to be clarified. Headlights, brake lights, turn signals. Because if the stop is invalid, the evidence could be suppressed. This is constitutional procedure in action.
I mean,
Would you like us to call Officer Judge to clarify?
yeah, I guess I'll give you a bit of time for, just toma asiento allá, por favor.
Today's hearing wasn't about whether people drank. It wasn't even about whether they might have been impaired. It was about whether the state met its burden at the probable cause stage. Twice, the judge found the evidence too thin, emphasizing that odor alone is insufficient. In another case, she demanded better articulation before accepting a fleeing charge. And in the final DWI, she scrutinized the legality of the stop itself before moving forward. This is how constitutional safeguards operate in real time. It's not anti-police, it's pro-due process. And it shows how critical, clear, detailed reporting is in criminal cases. If you found this breakdown insightful, make sure to hit the like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom analysis.